Hello, welcome back to class. This is American Federal Government. My name is Ken Hicks, and we have been covering the federal courts, which, of course, is one of the co-equal constitutional branches of government set up in Article 3. Judges are appointed for life. Their salaries cannot be reduced while they are in service, which is one of the ways back in the old days that they used to get judges to retire, would be by zeroing out their pay. They can't do that under the Constitution. And judges are increasingly a contentious part of the political process. And so as a consequence, the federal courts are taking on increasing importance. So what are we going to learn today? Most cases that reach the Supreme Court come by appeal. So we're going to talk about the Supreme Court's very extensive appellate authority. And then we're going to talk a little bit about the Supreme Court, the influences on the Supreme Court, which include, of course, kind of judgments about activism. Again, to what extent are judges willing to inject themselves into what are otherwise political processes? And then we'll just kind of conclude with some questions about what we think about the courts and their increasing centrality in American politics. So again, most cases appear before the court. Again, we mentioned, I think, in our previous presentation, the Supreme Court's original jurisdiction. An example of that would be if citizens of one state were suing another state because of activities taking place in that state. For example, Oklahoma has periodically sued the state of Arkansas because of the chicken farming and all the waste that comes into the water, into Oklahoma's watershed from Arkansas. That's an example of the Supreme Court's original jurisdiction. So the appellate power, again, is significant. The Supreme Court could not do its job of adjudicating the millions of disputes that appear before it unless it could control the flow of cases. And again, today, and I think I mentioned in my previous presentation that prior to the 1920s, the early 20th century, as the size of the American federal state was growing, the number of cases that were being called before the Supreme Court were rapidly expanding. And so in the 1920s, Congress passed the Judiciary Act, which basically gave the Supreme Court control over its docket. They basically could refuse to hear a case, in which instance that case would be final, whatever the lower court had decided. So today there are basically three kind of filters that create a motivation for the court to accept a case. The first one is broadly conceived what we call cases and controversies. And quite often, if you'll see cases appearing in multiple districts that are going up to the circuit courts where controversy, where contradictory decisions are being reached at the lower level, that's one of the areas where the court is likely to act. The second one is the idea of standing, which I'll address in a moment. And the third case is the idea of mootness, which again I'll talk about in a second. So cases and controversies, there are again kind of three of these ideas. Article 3 of the Constitution and Supreme Court decisions define the judicial power as applying to cases and controversies and not to political questions. And again, what is a political question? From the very start, the Supreme Court made the decision, first and foremost, that they were not going to act as an advisory body to either the president or to Congress. In fact, George Washington tried to pull the court into an advisory capacity, and the court basically said, nope, we are a separate and co-equal branch. We do not act as a counsel for the president. Okay, so that is one of the reasons why you actually have a White House Office of Legal Counsel. That is their job. It's to advise the presidency on the legal or constitutional status of any question. Another idea about political questions, historically, the Supreme Court had declined to rule on issues related to redistricting. largely because they argued these were matters that were determined under the Constitution by the state legislatures, therefore it was not justiciable. In the 1960s, the Supreme Court handed down two very important decisions, one of them being Baker versus Carr, and the other one being Reynolds versus Sims, which effectively said the Supreme Court does have an obligation to basically uphold foundational political principles. And in those cases regarding gerrymandering, it meant that the court had to uphold the right of one person, one vote. One of the things that was happening at the state level was that gerrymandering had reached a point where they were basically, the size of legislative districts were becoming radically different. And that meant that lower population districts were still electing the same number of representatives as much more densely populated districts. And that really upset the value or the effect of one person, one vote. Okay. Hold on a second, I'm seeing something weird here. Okay. The second idea is that, parties of a case have to have standing to bring suit, okay? So standing basically means that you are adversely or otherwise affected by a policy or program or executive decision, okay? One of the recent examples of the rejection of standing was that a group of what they called themselves concerned doctors had brought a suit in a district in Texas that only has one judge, who happened to have been appointed by Donald Trump and who happens to have been a movement lawyer within the anti-abortion movement, a guy by the name of Matthew Kacsmaryk. And he basically accepted that these doctors, none of whom actually were OBGYN folks, that they actually had standing to challenge the Food and Drug Administration's loosening of regulations regarding abortion dealing drugs, mifepristone and misoprostol, or I think those are the two. In any event, the case ultimately ended up before the Supreme Court, and the court rejected the idea that these folks had standing because they were not, frankly, affected by that decision. One of the arguments in the plaintiff's brief was that, in the event that they appeared, that someone came to them that had presented symptoms of having had a miscarriage or something like that would bring them somehow pain and suffering. And that frankly was a fairly ridiculous argument. Mootness refers to a criterion used by courts to basically say that this is no longer a case that requires resolution. A few years back, when the Trump administration was still in place, New York City had basically passed a much more restrictive gun access law, and that case was being challenged. And ultimately it came back, but it was challenged. In the meantime, New York City basically withdrew the statute. And so in that instance, that would be a classic example of mootness, where, again, the decision is no longer relevant, okay? Now it's not moving. Okay. It's very important to understand the idea of a writ of certiorari. There are a couple of different writs that are involved in this process. A writ of certiorari in Latin simply means to be made more certain. Okay. A writ of certiorari is basically a legal brief from a party that has been where there was a decision that was adverse to them. Cases viewed as deserving of review are often described as cert-worthy, okay? That's a classic kind of idea. And again, the way the court goes through this is that they'll get hundreds of these kinds of appeals in any given session. Basically on a month-to-month basis. And what will typically happen is each of the justices' clerks will then go before, they'll get together and they'll, okay, yeah, I'll get it. Oh, I went back, yeah.
We'll have to look at it when you're done.
Yeah.
I'm not sure why it's not presented.
Yeah. Okay. So again, the idea of cert worthiness and the clerks of the court, and many of whom are basically just, fresh out of law school, albeit the best law schools in the country, these folks are then going to come before, going to get together, and they're going to take each of these writs of certiorari, and they're going to write up basically one-page briefs that are going to lay out what is known as the gravamen of the case. Here are the issues that are being addressed. Here are the precedents that are being, that would apply. And here is basically what we think is going on with the lower court's decision. So there are thousands of petitions for writs of certiorari. And again, remember, a writ of certiorari is an order from the Supreme Court or from a higher court to a lower court saying to them, we're going, deliver up all documents relevant to this particular case. So there are thousands of these petitions filed every year. Usually they come in, on a month-to-month basis. And since 1972, most of the justices will participate in what is known as a cert pool, where the justices' clerks write very brief summaries. Because again, you're dealing with thousands of writs, many of whom, or appeals, many of whom could be hundreds of pages long. I once spent a summer in the law school library of the University of South Carolina, printing up all the writs, all what were known as amicus briefs, which I'll talk about in a minute, related to a case dealing with abortion. And that creates, again, it creates an enormous volume of material that you're looking at. So again, this kind of shows you kind of the escalation. And again, what is going on? By the time you get to the 1960s, you're dealing with an enormously sharp rise in litigation, right? These are the cases that are filed in the Supreme Court from 1938 to 2018. Now, what is happening in this, over this period that is causing this enormous spike of litigation? First and foremost, you're just getting, the population is expanding very rapidly. Secondly, by the time you get to the 1960s, you're beginning to see important issues like civil rights, like environmental regulation, that are coming, all these things are happening in the 1960s. And that is creating an enormous sort of ground for increases in litigation. Okay, so that's kind of important to keep in mind. There are other avenues of appeal, typically few cases. Typically there are 80 or fewer that will get a full hearing before the Supreme Court. There are a handful of cases that appear before the court by other means. And one of the primary ways that that's going to happen is, for example, a writ in forma pauperis. Now that is also Latin for a writ in the form of a pauper. Most people who are in prison, for example, if they are trying to appeal their case, will make that kind of appeal, where they're basically looking to try and identify a reason, a rationale for why their case should be reheard or somehow kind of vacated. The classic example of that is the case Gideon versus Wainwright, which was a case in which a guy this was in the early 1960s, he was an itinerant, we would call him a hobo these days. He was just a casual worker. He was accused of having broken into a store and having stolen some cigarettes or some candy or something like that. He basically, this was in Florida. He was brought before a criminal, a magistrate. He requested legal counsel. He was told that in cases that were not capital, the state of Florida did not provide legal counsel. So he attempted to defend himself at trial. Ultimately, was convicted. He wrote, he basically went to the prison libraries and learned what he could and wrote on a piece of legal paper a writ in forma pauperis. Now, ultimately, the Supreme Court determined that they would hear that case because it was a situation that many members of the court were very concerned about. And so they effectively accepted Clarence Earl Gideon's appeal to hear his case, to say that being deprived of legal counsel likely cost him his freedom. They actually assigned a very famous constitutional lawyer, a guy who was very close friends with then Vice President Lyndon Johnson, a guy by the name of Abe Fortas, to defend Clarence Earl Gideon in the Supreme Court. And Fortas's argument was that states like Florida, and there were several, that did not provide legal counsel in criminal cases were creating a very dangerous situation where judges were placed in an untenable situation where they had to make a determination, looking at a person just on their appearances, and make a determination that that person was or was not competent to try their own case. And effectively, the decision of the court at the time in Gideon versus Wainwright was that lawyers in criminal cases are necessities, not luxuries. And Florida and many other states had to retry all those categories of cases where people were denied access to legal counsel and who were subsequently convicted. And the results were that in many instances, those folks were basically found not guilty because they had effective legal counsel. And so what does that tell you about the state of criminal law in the middle of the 20th century? There were a lot of people like Clarence Earl Gideon who were simply in the wrong place at the wrong time and had suspicion drawn upon them and were arrested by police and subsequently tried and in ways that basically said that they were not in a position to effectively defend themselves. One of the things that you find if you ever serve in a jury is that when people act as their own defendant, as their own legal counsel, they are often at a disadvantage. One of the famous 19th century lawyers one of the giants of American jurisprudence, Daniel Webster, once said, I know enough about the law to know that if I'm in legal trouble, I need a lawyer. And so that really reflects this belief that was widespread at the time, that again, in order for the adversarial process of enforcing criminal law to work, people who have been accused of crimes have to be competently represented. And it's unfortunate that quite often, in particular in cases where indigent people have been accused of murder and where they may face a capital case, where they may face the death penalty, they nevertheless are not given adequate counsel because quite often they have to rely on public defenders who are oftentimes fresh out of law school, are not, they don't have the experience at that point to try a death penalty case, and oftentimes, frankly, are overwhelmed. They may have such a large caseload that they simply do not have the time to prepare. Which gets back to the problem that, the overall problem that we have in our system with the over-reliance on plea bargains, because quite often public defenders are going to take that path of least resistance to try and lessen their load. Now, I'm not trying to cast aspersions on public defenders. I think most people who find themselves in public defenders' offices are good people who are conscientious and who believe in the legal process. They simply don't have the resources to do the job as effectively as they otherwise might. So who are Americans and who becomes federal judges? When you look right now at federal judges in the United States and you look at it by race and gender, what you find again is that white men are pretty massively overrepresented. They are 3 times, close to 3 times, overrepresented compared to women. That black men are slightly perhaps overrepresented, but black women are underrepresented. That Latinos and Asian American men might be slightly overrepresented, but Asian American women are not. Latino women certainly are not. And that reflects the kind of the hard reality that it's harder for certain minorities to get to a place where they could become a judge. It's more difficult for these folks to get through a law school, to pass a state bar, to practice law in a way with a kind of distinction that would bring you to the attention of someone that might otherwise nominate you to become a federal judge. So this is a challenge that we are, still working on in the United States. Appointments to federal judges by administration. Again, if you look at the Biden administration, it's kind of evenly split. It has tended overall that Democrats have tended to try and be more pluralistic in their nominations to the federal judiciary. Again, Clinton slightly more men, white men than otherwise. But Clinton, Obama, and Biden overall appointed a lot more diverse groups of people into the federal judiciary than Trump or either the Bush or Reagan administration. Certainly Reagan, again, to some extent, Reagan reflects the times as much as anything else. He was in office from 1981 to 1989. But he appointed close to 80% of his judges were white men. Again, by judicial selection, what kind of, how do states elect judges? In many places, you do gubernatorial appointments through a nominating commission. I actually like that. I think, especially if the nominating commission is bipartisan, that is a good way to do things. You focus more on the qualities of individual judges rather than on partisanship. One of the worst ways to do it is through partisan elections. Again, what's the problem there? You find in states like Louisiana, which I don't want to single out Louisiana necessarily, but Louisiana has a frankly long history of corruption, and a lot of it has to do with the influence of the oil and gas industry in that state. Sounds familiar to Oklahoma, doesn't it? And where Louisiana relies on partisan elections, and you have the oil and gas industry spending large amounts of money ensuring that judges get elected, you find that it becomes a bit problematical, right? Because these are people who are going to get sued and who are going to be brought into state courts, and they're going to be judges that were, whose elections were basically secured by that industry. Very similar thing happens, here in Oklahoma. The governor, nominates, and then periodically judges have to go up, especially for the Supreme Court and for other courts, within the Oklahoma state system. Then they have to go through a retention election process. And in this last election process, you had 3 judges who were nominated by, Democrats. Back in the day, they were probably in most instances nominated by Brad Henry because he's the most recent judge, or Walters. Again, those were the last 2 Democratic governors, and that was a pretty long time ago. These folks had a lot of money sent their way in negative advertisements by the Oklahoma oil and gas industry to try and defeat them. Now, ultimately, only one of them went down. 2 of them were able to successfully, withstand that negative attack, those negative attack ads. So, beyond the judges, there are other key players in the judicial process. One of them is, of course, the Solicitor General. The Solicitor General is the 3rd-ranking official in the Justice Department, and is basically viewed as the top government lawyer in all cases argued before the Supreme Court. Now, the Solicitor General is not the President's lawyer, okay? The Solicitor General works within the Department of Justice and is supposed to be independent of the presidency, okay? There is supposed to be sort of a wall of separation between the office of the President and the Department of Justice, okay? So the Solicitor General is the 3rd-ranking official. The Solicitor General typically exerts a strong influence over the screening of cases that any federal agency that wishes to appeal to the Supreme Court is going to have to go through. The Solicitor General can engage on a case, even when the federal government is not a direct party, by filing what are known as amicus curiae briefs, and that is Latin for friend of the court. Okay? The court's members oftentimes give special attention to the way the Solicitor General will characterize issues. A famous example of that was during the administration of George W. Bush, Theodore Olson, who actually recently passed away, was the Solicitor General. He was also well known as being a close friend of Associate Justice Antonin Scalia. The two, they helped form the Federalist Society together. They were founding members. They socialized together. Their families vacationed together. Even before that kind of a close relationship was brought to light, Solicitor Generals have oftentimes been described as the ninth and a half justice, for the simple reason that the Solicitor General oftentimes appears before the Supreme Court more often than other judges. Okay? So you also have the idea that another kind of important set of players are law clerks. Okay? Each federal judge employs law clerks for legal research and to assist in the preparation of opinions. Law clerks will help justices draft opinions. They will kind of get together with a judge or with a justice. They'll kick around ideas for basically what is the rationale behind the decision they have reached. Each Supreme Court justice is assigned to 4 law clerks, and typically these folks are basically the top graduates of the best law schools in the country. Justices, for example, who may be from California or from the West, will want somebody that came from one of the great law schools on the West Coast, like University of Cal Berkeley, Stanford School of Law. Justices from the South will want to, basically get a law clerk from Vanderbilt or from Emory University in Atlanta. There are a number of very good law schools. Obviously, justices with Ivy League pedigrees are going to pick from, Harvard or Yale or Princeton, one of those kinds of law schools. The relationship between justices and their clerks is generally a closely guarded secret, but it's increasingly becoming obvious that the justices rely heavily on their clerks, who in many instances are really young, really new to the legal profession. And oftentimes highly ideological. There is a former clerk to a retired associate justice by the name of Harry Blackmun. The guy who wrote the book was a guy named Edward Lazarus. He wrote a book called Closed Chambers. This came out in 1998, and a lot of people within the legal community condemned Lazarus because he was basically breaking the code, breaking the code of discretion that law clerks really don't tell stories. But Lazarus basically wrote about justices who often yielded a great deal of power to very immature and oftentimes ideologically driven law clerks who use that power to manipulate their employers, who are again the 9 most influential people as it relates to the practice of the law. Several sitting justices were in their time law clerks, including John Roberts. I want to say who else? Several of the new the new people, including Amy Coney Barrett and Brett Kavanaugh and Neil Gorsuch. So again, over time, as the courts have become more and more important and their jurisdiction over federal decisions and policies has tightened, that has created enormous incentives for interest groups to lobby the courts. And again, one of the main ways they do that is through the filing of amicus curiae briefs. Interest groups and political movements try to persuade the justices to listen to their grievances, and it's not, it's not rare for Supreme Court justices to include the rationales from amicus curiae briefs that they find persuasive. Lawyers representing interest groups oftentimes try to match the proper client to the proper case so that the issue in questions are most dramatically framed. They oftentimes engage in what is known as venue shopping. I just mentioned an instance where that occurred, where a federal district judge that is known to be hostile to abortion and to reproductive rights generally, basically heard a case from a group of right-wing doctors that want to restrict access to the two main drugs that are used in chemical abortions. So again, when possible, they're going to try and pick a court with a sympathetic judge. Again, that is known as venue shopping. There's also the idea of pattern of cases approach, which is the most effective approaches for getting a case accepted to the Supreme Court. And again, what they're going to try to do is artificially, to some extent, set up an environment where there are conflicts among the circuit courts as to outcomes, because they want cases to get in front of the Supreme Court. It's important to keep in mind that Republicans and conservatives have had a majority on the court for close to 40 years. And, it doesn't mean that they win every argument. But it is a reality that Supreme Court justices and federal judges generally have a judicial philosophy that is at least tinged by ideology. And what it means is that a conservative judge that hears a case where conservatives want a particular outcome, they may be willing to bend the law a little bit. Same way with liberal judges, but they're not willing to twist it into a pretzel to try and get a clear ideological outcome. That is a situation, again, where the more you do that, the more obviously political you appear. And the more likely it is that your decision is going to be controversial, become politicized, and where you're going to get an outcome that as an ideologue, you're not going to be happy with. Supreme Court's procedures, again, the Supreme Court's decision to accept a case is the starting point of what is oftentimes a very lengthy and complex 10-step process. Now, the court also can act very quickly when they choose. One example of that not happening is again dealing with the independent counsel, Jack Smith's appeal of a federal district court's dismissal of the documents case, where Donald Trump was accused of having illegally hoarded federal documents. They could have expedited that case. A very similar situation happened during the Nixon administration, where it took them less than 3 weeks to render a decision. In this instance, they basically delayed hearing the case until it was effectively mooted by the November elections. Briefs themselves are written documents in which attorneys explain why they think a case should be decided in a certain way. This is, typically both sides of a legal dispute, and anybody kind of surrounding that dispute are going to file a brief, which oftentimes can run to hundreds of pages, saying, here's why you should rule in the favor of my client. Oral arguments allow each side to present their cases before justices, who are frequently going to interrupt to ask questions. And that's actually increased in recent years because they used to just spontaneously, a justice would just butt in and ask a question. And what we discovered, what legal scholars discovered from studying those kinds of decisions is that men frequently interrupted, the female justices, and frequently would run over female lawyers. And so these days they have changed the procedures, and this is largely due to COVID as well, where nowadays each justice is going to get a certain amount of time to ask questions. And so they go in order typically of seniority. So again, oral arguments have that kind of quality where you're looking to see, you're testing to see what will the outcome be. And you can oftentimes get an idea of how the court is going to rule based on the tenor of the questions. And you can absolutely see that today because, again, Republicans have a 6-3 advantage on the court. There are 6 conservatives to 3 liberals. So if you see all 6 conservative justices pushing a particular line of argument, you can pretty much kind of read the tea leaves and get an idea of what those justices are going to say. Conference is basically where the justices meet. They speak by order of seniority, with the Chief Justice always speaking first. That places the justices in a venue where they can discuss the case in private on typically the Wednesday or Friday following an oral argument. Now again, the Chief Justice has a unique influence over the procedures of the court. John Roberts, who is the current Chief Justice, is uniquely positioned to say what the case is going to be about because the Chief Justice speaks first at conference and votes last in terms of how a decision is going to be rendered. And so in instances where you end up with a 4-4 deadlock on the court, the Chief Justice holds their vote and is in a position to decide literally who will win. And then as the Chief Justice on the majority side, he can assign which member of the court in the majority will then write the majority opinion of the court. So this kind of gives you an idea of how long it can take. In this instance, this is a case that basically took roughly a year from the time that the petition for a writ of certiorari is filed until the time that a decision is rendered. And if you look again, typically about 4 weeks after the petition was filed, you get the filing. Basically, the court says you're going to issue the writ of certiorari. You have a month. Both sides of the case have a month to file their briefs, and then you solicit any kind of amicus curiae briefs that might be come in support of the petitioner or the other person. And then a month after that, a little bit over a month after that, you get the brief of respondents. In this instance, it was American Federation of State, County, and Municipal Employees for Council 31. That was in opposition filed. And oftentimes what you're going to find is that the sides of the case will oftentimes need more time, and they will file for additional time, which normally is going to be granted. You want to make sure everybody has sufficient time to do the best job that they can do. The case is then distributed among the justices for conference. The petition is granted, the petition for a writ of certiorari is granted, and then you schedule a date for oral argument. In this instance, it was set for February 26th of 2018. The briefs and amicus curiae are filed by December of 2017, and then in January, briefs are filed on behalf of the other side. And then finally you get oral argument, which typically lasts for 1 hour. Then you get the conference, then you get the votes, and oftentimes that can take a while, okay? Sometimes it can take months from the time that oral argument occurs in the conference before the actual decision is announced. And oftentimes what is going on there is that the person that was assigned to the majority is going to write the opinion with the help of their clerks, and then that will get distributed typically among all the justices. Occasionally, though, it will only go to the majority justices. And the majority justices may say, I would like to see this changed in this particular way. There are times when a majority decision can be so jarring to a member of the majority that they may defect. And in instances of a 5-4 decision, that may shift the outcome entirely, which would lead to a redrafting of the majority opinion, which again can elongate that process. So there's a lot of kind of horse trading that will go on among the justices in terms of what goes into a majority opinion. So opinion writing, again, the Chief Justice or the senior most justice in the majority writes or assigns to another member of the majority the responsibility for writing the majority opinion. Now, the majority opinion is important because that is the opinion of the court, and it has the force of law. and it can significantly alter legal interpretations of all prior precedents. So when a Supreme Court decision comes down, that becomes part of the precedent related to that case. Remember, we talked about English civil law and the importance of precedent. Okay? So one example of this is Smith versus Allwright. It was handed down in 1944. Once an opinion had been drafted, some members of the majority may want to write a concurring opinion. Now, what is the value of a concurring opinion? Basically, a concurring opinion is saying, I vote with the majority, but I would have reasoned the case differently. I would have provided a different set of rationales for how the decision should be managed. Okay? So again, the simple way of looking at that is, I agree with the decision. I don't agree with how we got to that decision. Okay? The example of Smith versus Allwright is an example of the importance of writing, of how a majority opinion can be assigned. In that particular instance, there was a case dealing with segregation. And initially, the Chief Justice was going to assign the case to a Jewish member of the Supreme Court. And one of the other members of the majority basically approached the Chief Justice, actually wrote him a letter and said it would be a mistake to have this person from New York, this Jewish person from New York, assigning the majority opinion. That you really want to make sure that this is an opinion that people affected, that people in the South are going to understand that the court is writing from the perspective of someone like them. And so they assigned the court, the opinion writing, to a more conservative member of the court who was from the South. Dissenting opinions this is what happens when someone who is in the minority and doesn't agree with the majority, they might choose to write a dissenting opinion. Dissenting opinions signal opposition. They basically offer a counter rationale for why the case should have been decided differently. The right of the minority to write a dissenting opinion is an essential aspect of due process of law and of rule of law generally. In the past, partisan polarization has oftentimes produced lots and lots of 5 to 4 decisions, very narrow decisions, which basically encourage justices to write dissenting opinions in the prospect of persuading a future majority to see cases differently. Okay, one famous Associate Justice, John Marshall Harlan, who served on the court, for close to 40 years, or for 33 years, was oftentimes known as the Great Dissenter. He was one of the folks that dissented in the case of Plessy versus Ferguson. He basically said, or no, actually in what was it? Sanford, the slavery decision. He basically said that, no, it was the Plessy decision in 1896. He basically said that the Constitution is colorblind. And we have made it so. Amendments to the Constitution have basically made these kinds of discrimination illegal. That dissent, provided a future rationale for the NAACP to challenge, the legal precedents, which we discussed about in our discussion of civil rights. As basically saying, if you take the language of the 13th, 14th, and 15th Amendments seriously, you cannot allow discrimination. It's simply not tolerable within our Constitution. So this gets us to a very important reality, and that is that judges and justices they sit on the bench, but they are not neutral as it relates to American jurisprudence. They have beliefs about American law and the role of American law in the Constitution, in the workings of our government. And so there are a number of factors that influence court decisions. And two of the most important are the idea, again, of ideology and also the idea of the role of the courts in kind of upholding the constitutionality of the law and process. So for most of our history, the judiciary has generally played a conservative role in our politics. And by conservative, I mean enforcing a kind of status quo. Okay, many versions of conservatism reflect this idea that conservatism is about managing change and slowing down the pace of change. So throughout the court's history, the Supreme Court in particular has shaped and reshaped the law through its use of judicial review. The Supreme Court in the 19th century acted as a profoundly conservative political institution. They preserved slavery for as long as they could. When slavery was no longer tenable as an economic and political and social institution, the Supreme Court generally slowed the rate at which blacks and other minorities were basically allowed access to basic citizenship rights. Okay? In the middle of the 20th century, really from around 1954 until around 1968, the court acted in a dramatically liberal direction. They moved in a dramatically liberal direction. They acted decisively to expand civil liberties, civil rights, and the scope of regulatory policies generally. This was a period, again, when you hear conservatives criticize the court, they are almost in every instance criticizing the expansion of civil liberties, the protection of civil rights, and the assertion of regulatory authority of the federal government to prevent the destruction of the environment. Okay? These are the consistent themes with which conservatives find problems with the court. They would rather have seen different outcomes. You have to ask conservatives, do you really think that civil rights should not exist? When you hear people decry this idea of diversity, equity, and inclusion, which is effectively an argument that we should, tolerate people who are different from us, and we should not discriminate against people who are different from people of my color skin, then that is what they're basically saying. They're saying, I demand a right to discriminate. That is what all this stuff really revolves around. Okay? Since the 1990s, the court has consistently retreated from previously liberal decisions, and in fact, in the last 10 years or so, they have moved dramatically to curtail the regulatory power of the federal government, as I mentioned in my previous discussion. And they have tried to tamp down on many civil rights related issues. For example, they have basically made it impossible for schools to take discrimination into consideration in their admissions policies. They have basically said you have to adopt something like merit or whatever passes for merit as the basis for your admissions, for how you decide on admissions. And almost immediately, what you found in many of the major elite institutions in the United States, the number of minorities has measurably decreased. And I'm thinking the majority of the Supreme Court think that's a good thing. Okay? Institutional interest. The Supreme Court and the justices of the Supreme Court and the judges of the judiciary are typically aware of the court's place in history, and most kind of are instinctively protective of the court's influence and reputation for integrity. What does integrity mean? It means, as a judge, you interpret the laws as the laws are written. You uphold that understanding of American jurisprudence. Okay? A classic example of the court basically kind of bending before the gales of public opinion occurred during the Great Depression. Early in the New Deal era, the Supreme Court, which was comprised of 9 old men, old white guys, who were appointed almost entirely by Republicans because there hadn't been a Democrat on the court. By 1933, when Franklin Delano Roosevelt came into office and you had the dramatic 100 days, the last Democratic president had been Woodrow Wilson in 1921. And I don't recall if any of the members of the court were, on the court were appointed by Wilson at that particular point in time. And so there were basically 9 conservative judges who were striking down, key aspects of the New Deal era at a time when the American public had, by enormous majorities, said, we want change. We want fundamental revisions of government. And so, what you got was the increasing perception, particularly among political elites, that the Supreme Court was acting in a partisan manner. That led Franklin Roosevelt to propose what was known as the court packing plan. Now, I want to emphasize, as a historical matter, court packing in that period was not popular, despite the fact that Franklin Roosevelt, who was the dominant political figure of that era, despite the fact that he put his name behind it, he campaigned on it. Many Democrats campaigned on the idea of packing the court. Lyndon Johnson, I believe, was elected the first time in his career as a supporter of Lyndon Johnson's court packing plan. But overall, Democrats did not prevail, and increasingly the perception was that court packing was simply not going to work. Nevertheless, that kind of political pressure ultimately changed the approach of the Supreme Court. From that period forward, the Supreme Court began holding New Deal era programs as constitutional. And again, that was a result of a switch of a couple of justices in recognizing that that they were becoming perceived as political, and the more political the court is, the weaker it frankly is. Okay. Now, in the contemporary era, as Chief Justice, John Roberts has, for the most part, appeared to have institutional concerns about upholding the constitutionality of, for example, of the Affordable Care Act in 2015 and again in 2012 and again in 2015. And he has often provided the fifth vote for cases that where he basically joined with another conservative and the liberal justices to constrain the more activist impulses of the more conservative justices. But of late, he has certainly joined with the conservatives in basically rendering Donald Trump immune to anything related to his official actions. Now, think about it from this terms. If a president is using his official actions to engage in corruption under the decision that the Supreme Court has held, he is immune. He cannot be he can be impeached and removed because that is a constitutional process. But he cannot be accused of a criminal action, even if he is overtly, in plain sight, accepting bribes to undertake a particular act, which is the essence of quid pro quo relationships that has been the very narrow definition of bribery in American jurisprudence these days. The idea of activism and restraint are very important for understanding the role of the courts, okay? Judicial restraint is the de facto or the default setting of most justices and most judges. Federal judges will tell you if you ever have a chance to appear, to have a judge come to your campus and talk to you. We've had a couple of judges who have come to campus here at Rogers State University, and what they will typically say is, I am an adherent to the idea of judicial restraint, okay? Which means, as an unelected person, I am loath to inject myself into the political process. And I am only going to hold that an action of the Congress or the executive branch is I'm only going to act to strike it down if I view it as clearly in contradiction to the Constitution. So judicial restraint is basically an argument that judges should avoid making decisions that bring them into political conflict with the other branches of government. Judicial activism is an argument, and historically the conventional wisdom is that it's liberal judges who are activists and it's conservative judges who are advocates of restraint. That's really not true. But advocates of judicial activism basically make the argument that there are times when the courts have to adjudicate contentious issues that require a resolution. Okay, so the argument of defenders of judicial activism will look, for example, to the decision in Brown versus Board of Education. They will say that the Constitution, as properly understood, forbids the kinds of discrimination that were used in the South and in some places in the North to justify discrimination against minorities. Okay. That is an argument basically saying sometimes the court must act when injustice has reached a certain level and where there are situations where it appears that the politics cannot produce an accommodation. Okay? So many arguments, again, the late Ruth Bader Ginsburg basically said, I am an advocate of judicial restraint. Nevertheless, obviously Brown versus Board of Education was correctly decided. But she would also have argued at various points that the decision in Roe versus Wade was a bit precipitous, that perhaps the political processes should have gone a little bit further so that we could have been in a better position, so that we could see whether the politics was ultimately going to deadlock or whether there were going to be reasonable accommodations. The court's decision in Dobbs versus Jackson Women's Health is again, this is an instance of judicial activism. But the majority of the court is effectively saying, no, we are not engaging in activism. We are stopping a previous instance of judicial activism. We are arguing, Samuel Alito arguing for the majority was basically saying, we believe that this decision needs to be returned to the states and where the states can make determinations as to the best accommodations. And so that's where we are today. Now, nevertheless, here's the problem. Neither side of this political conflict as it relates to women's reproductive health are satisfied with federalism being the way that we resolve the issue. If you absolutely believe that women's reproductive rights must be protected, then you don't like the fact that Oklahoma and Idaho and dozen other states have such strict restrictions on access to abortion, because you believe that women are dying as a result, that women's health outcomes, just in terms of their reproductive lives, are not being adequately protected. And if you are an absolute opponent, if you believe that the moment the moment of conception, that a fetus is an absolute human being deserving of the same right of protection under the 14th Amendment as every other person, then you are completely unsatisfied with those states that have passed constitutional protections mandating that women have a right to terminate a pregnancy up to the point of viability. That is the problem that we have. The conflict between these two sides is not subject to accommodation. The viewpoints are too absolute, and I would argue that most of the absolutism is on the people on the side of folks who are absolutely against abortion in all instances. And I would also argue that for the most part, the rationales they offer are religious in nature, which in my view is a violation of the Establishment Clause. So the point of this is that activism and restraint overlap, and there is a lot of gray areas, but it's not always synonymous with the idea that liberals are activists and conservatives are advocates of restraint. In fact, this Supreme Court, dominated by 6 conservatives, has been far more activist. And again, what does it mean to say that you are activist? It means you are willing to say, you are willing to strike down, to take action, to strike down the activities of Congress or the executive branch or the presidency on the grounds that you are saying that what they're doing violates either the law or the Constitution. And another example of activism is Shelby County versus Holder in 2012. The Supreme Court, or I mean the Congress, had passed, and it was a Republican Congress at the time, passed with very little fanfare the renewal of the Voting Rights Act of 1965. Those decisions, especially the aspect of the Voting Rights Act of 1965 that required pre-clearance for all jurisdictions that wanted to pass laws related to voter eligibility. This was Shelby County, Alabama. Alabama had been a state that had engaged in voter suppression. Therefore, if they were going to change voting laws, they had to go to the Justice Department's Civil Rights Division to obtain what was known as pre-clearance. The Supreme Court struck that down. Likewise, in 2014 in McCutcheon versus FCC, the court's 5 conservative justices, were clearly acting in an activist manner, striking down provisions that didn't accord with their ideological and/or policy preferences. And again, they have invented what is known as the major questions doctrine as a way of reining in the regulatory authority of federal agencies. They invented that legal rationale. It's not something that has existed prior to about 5 or 6 years ago. Ideology and partisanship. It's clear that the whole ideas behind activism and restraint, can amount to a smokescreen for justices' liberal or conservative attitudes. And the conservative justices have very frequently taken to public venues to protest. They are not ideologues. In fact, Amy Coney Barrett, shortly after being named to the Supreme Court, in a bum rush, she was rushed onto the court. Literally, that happened in a matter of weeks following the death of Ruth Bader Ginsburg. That happened literally within a 3-week period. It was one of the most rapid confirmations ever. She then appeared at the University of Kentucky in Louisville at the Mitch McConnell Center, incidentally, to give a public address to an entirely Republican audience that they're not a bunch of ideologues. Okay. And the similar, Clarence Thomas has done the same thing, going to Notre Dame, which is ground zero for the conservative, federalist, ideological movement related to jurisprudence. Clearly, the reality is that if a president is a Democrat, they're going to nominate people that are of a more liberal persuasion, and if the president is a Republican, they're going to go in a more conservative direction. The creation of a 6-3 conservative majority has led again to speculation that the court will move in a decisively more conservative direction on issues like abortion, gun rights, and regulatory policy. And this slide is dated because the reality is they already have. Okay, they struck down abortion rights. They struck down Roe versus Wade. They have struck down the regulatory authority of executive branch regulatory agencies, and they have basically in the Brunner decision related to gun rights, they've effectively said that if there was not a law that allowed the banning of guns that existed in the 19th century, that no new regulation can be allowed. And so they have created an environment where virtually anyone can get a gun, and where women, if you are in the wrong state, you have no access to reproductive freedom. Again, contemporary comments by Justices Barrett, Breyer, and Thomas have all attempted to refute the notion that the justices are political creatures. And again, what they're trying to point to as evidence of that is that of the 80 or so cases that they'll typically hear, many of those cases are 9-0 decisions, because after all, the justices are lawyers. They understand the law. They know how the law should be interpreted for the most part. And most decisions that go to the court are not going to be that controversial. But the fact that they have to protest that they are not political creatures suggests that they might be political creatures. So judicial power in politics, the federal courts have, again, expanded their role and their influence over American politics, but they still operate under significant constraints. First and foremost, the courts are passive institutions. They have to wait until a case is brought to them before they can issue a ruling on, adjudicate the constitutionality of a ruling. Secondly, the courts traditionally are limited to the kinds of remedies they can provide, offering relief or assistance only to individuals and not to broad social classes. Third, the courts lack enforcement powers. They have to rely on the acquiescence of the other political institutions. Fourth, because court judges and justices must be nominated by the presidents and are subject to the Senate's advice and consent authority, other institutions can influence the composition and character of the courts. In many areas, federal courts' jurisdiction originates with Congress and not with the Constitution. In other words, Congress can control the venue and can control the jurisdiction of the courts. So, I'm going to conclude. The federal judiciary, what do we think? Originally, the framers conceived of the judiciary's role as that of protecting individual liberty from government. In many instances, conservatives on the court would say that they are attempting to advance individual liberty. They are oftentimes doing so in incoherent ways. Americans of all persuasions seem to view the courts as useful instruments through which to pursue their ideological and policy goals. While conservatives want to ban abortion and maximize economic productivity, while liberals on the other side want to protect workers' rights in the workplace and reduce the role of private money in political campaigns. And they also want to return to women basic reproductive rights. I think those are going to be the campaign goals going forward for Democrats going, in the process. And it really illustrates a basic challenge in American politics, that it's easier to be in the minority and to attack the actions of the majority than it is to govern. Because, as I've said probably at multiple points in this class, to govern is to choose, and to choose is oftentimes to potentially alienate people who are part of the majority's electoral coalition. For example, Donald Trump ran for president in 2016, saying that he was going to nominate judges who would overturn Roe versus Wade. He did that. He got 3 justices. They joined in a 6-justice majority to overturn Roe versus Wade. And then Republicans began realizing just how unpopular that decision was. In 2024, Donald Trump basically said, I will not support any kind of national legislation on abortion, because he understood that would, that campaigning as a candidate, as a anti-abortion candidate, would be a loser for him in particular and Republicans in general. So he fundamentally has changed. Now, as president, he hasn't even been sworn in yet as I shoot this video. But when he is sworn in, if Republicans in the House of Representatives and the Senate pass a national abortion restriction, will he sign it or will he veto it? He has said he will veto it. The question is that true? Because he, of numerous states, I think 6 out of 7 states basically put on their constitutions, including several conservative states, restriction, basically saying that abortion is a constitutional right in their state. In Florida, a similar kind of constitutional amendment failed, but it still got 57% of the vote. The problem was that the state question required a 60% threshold to be approved. The courts have created environments where politics are being unleashed, and that means that there are lots and lots of political coalitions that are moving back and forth between the two political parties. We're going to see what the future brings, but the courts are going to be the ones that are going to be deciding, on the constitutionality of a lot of these decisions. So if the courts are simply one more set of policy-making institutions, who is left to protect the liberty of individuals? Can you think of ways that Supreme Court decisions have affected your life? I guarantee you, every woman I have had in a classroom over the last couple of years is exercised in some way about the Dobbs decision. How could the court's decisions on health care influence the type of care you receive and its cost? How will its decision in the realm, for example, of immigration affect who will and who will not be able to call themselves Americans? Donald Trump came into power promising that he was going to engage in mass deportations. This is not the first time this was tried. The Eisenhower administration did a similar thing. They deported over 1 million people over a 2-year period. It was enormously disruptive. They violated many Americans' rights because they actually deported many Hispanic Americans on suspicion that they didn't belong in the country, and subsequently discovered that they were. Do you think those kinds of mistakes are going to happen now with this group of people doing the deporting? Given what we know now, do you view the court as the least dangerous branch of government or as an imperial judiciary? What evidence do you see for each characterization? I have made the argument publicly that I believe that the more politically the Supreme Court acts, the more they act beyond the realm of the law, and the more their policy preferences become obvious in their decision making, that they are creating a damaging set of environment, set of creation. They are creating a problem for themselves. Put it that way. Found myself in a grammatical snarl there. The more they are viewed as a political institution, the less power they will wield. And so that is the challenge that this court is confronting. How do they balance their need to uphold the Constitution and to interpret the Constitution against situations where they're going to be asked to twist the law to justify expedient political outcomes? I think that is going to become a relatively perpetual issue over the next 4 years. And on that note, I'm going to close. When we return, we will take up a related issue. We have dealt with the political institutions. We've dealt with Congress. We've dealt with the presidency. We've dealt with the judiciary. Now we are going to move to where the rubber hits the road. The last 4 of our presentations are going to deal with policy-related issues. On the one hand, we're going to talk about domestic policy for a couple of presentations, and then we will conclude with 2 presentations on foreign policy. I'll see you next time.